Yes.
Yeah, President Lordships.
Yes.
Item 12. I have put appeal here.
Hmm.
Besides this writ appeal, there are two writ appeals, namely writ appeal 41 of 2025
Hmm.
and writ appeal 23 of 2025, which are 43 of 2025, which are connected matters. And the other two matters.
No, one is 43,
41.
Yes,
41.
43 of 2025,
and other is
41 of 2025.
41 and 43.
Yes, these are all connected matters, but the other two are not listed. So all these matters may be listed next Wednesday.
Okay. Now. Other learned senior counsel, Mr. C.T. Jamil, appearing for the appellant. Next Wednesday, what will be the date?
25.
25. List this matter on 25 February, along with writ appeal number 41 of 2025 and 43 of 2025. Okay.
And again, Lordships, item 22, 23, and 25. In this matter, I am for the respondents.
Hmm.
The matter relates to a religious organization.
Hmm.
That is namely Assembly of Governments of Northeast India. Now, the office is run by a team of experts,
Hmm.
and the matter relates to the actions taken by the whole team.
Hmm.
During the pendency of the writ appeal, the election was held and a new team has been constituted.
Hmm.
I do not have the list, but the election is, fact remains that the election has been conducted
Hmm.
and a new team has been elected.
Hmm.
And the office is functioning by the new team.
Hmm.
Now, there is a reconciliation process going on.
Hmm.
And they want to review all the actions taken by the whole team.
Hmm.
So in view of that, Lordship, some time will be given, say, 4 weeks time will be given, Lordship.
Okay.
And the next occasion, I will also apply standard code.
Yes.
As far as the
Position.
my little friend is saying, I don't have any instruction to that matter.
Hmm.
But what is happening in the organization is one aspect of the matter, and the legality of the orders which have challenged here is a different thing altogether.
Hmm.
But however, if there is a change in the in the office bearers of the association, some time can be given to me and also verify. They will come up over 2 weeks.
Okay. The learned senior counsel, Mr. C.T. Jamil, item number 22. 22. The learned senior
22, 23, and 24.
24. Item number 22, write down. The learned senior counsel, Mr. C.T. Jamil, appearing for the respondent submits that the office bearers of the
AGI.
Assembly of
AGEI
Yes.
have changed and a new team has taken over. Therefore, Mr. Jamir prays for some time. We have also heard Mr. A.G. Muni, the learned counsel appearing for the appellants. Mr. Jimoni also agreed to that. Therefore, the prayer of Mr. Jamil is allowed. Least after 2 weeks.
Let it be after 3 weeks also.
Okay, then.
Organization.
Okay. After 3 weeks, along with item number 23 and 24.
May it please your lordships.
Yes.
Lordship, with the consent of the other side, I beg to mention item number 21 of the daily list, your lordship. Lordship, my senior Mr. K.N. Chaudhary has some personal difficulty in appearing today. May I kindly seek this matter be posted on the 11th of March, your lordship.
Okay. Well, what is your name?
T. Kashyap on behalf of Mr. K.N. Chaudhary, your lordship.
The learned counsel, Mr. D. Kashyap, appearing for the appellant submits that the learned conducting senior counsel, Mr. K. N. Chaudhary is not available today, and on that ground, an adjournment has been prayed for. I have heard Mr. N. Muji
For respondent 2 and 3.
for respondents 2 and 3.
No.
Heard MS, appearing for respondents 4 to 11. The prayer of the appellant is allowed. List on 11 March for hearing.
Much obliged. Much obliged.
Bless you.
Okay.
This lordships, I make the mention hearing item number 19. The lordship says seniors in this process, it's never with its other votes.
Okay, what is your name? The learned counsel, Mr. So-and-so. Appearing for the petition of subjects that the learned conducting counsel, Mr. V. Theo, is not available today, and on that ground, an adjournment has been prayed for. I have also heard, we have also heard Mr. N. Angami, the learned counsel appearing for a state respondents. The prayer for adjournment is allowed. When do you want it? Least after 4 weeks, along with item number 20 for hearing.
May I please?
Yes.
Lordship, I'd like to mention item 6 to 11. If this matter can be list after wait, my lord.
6 to 11.
Yes, madam.
Next Wednesday, no, it's a very short pattern.
That's all.
Short pattern.
When do you want it?
Next Wednesday. 25th Friday. Next Wednesday.
I'm asking for a big one.
Do it in the month of March. I'll give you a date in the month of March. On the request of Mr. N. Angami, the learned counsel appearing for the state respondents. The matter is adjourned today. Heard Mr. A. G. Muni, the learned counsel for appellant. This matter on 11 March, along with item number 7, 47 is different.
7 to 11.
These are different, not listed together.
Sir, analogous pattern.
Analogous matter.
Yes.
Let me club together.
Then along with item number 7, 8, 9, 10, and 11.
Undetermined.
Mr. Rashid.
Yes,
Maybe allowed to mention item number 16,
16.
hearing item 16.
Yes,
It can be listed on 11th of March.
okay. What is your name? What is your name?
Kohima.
On the request of the learned counsel MS. Board. On the request of the learned counsel MS Provi Tisuru. The matter is adjourned to hearing is adjourned today. We have also heard MS, what is your name? Appearing for respondent number 2. When do you want it?
11th of March.
List on 11th of March for hearing.
Mr. Lordships, I'd like to mention item 18, Your Lordship.
Hmm.
I've mentioned on behalf of my colleague V. Jimo, who's appearing for the states.
Hmm.
This matter will be listed after 2 weeks, Your Lordship. I've taken the concern meeting.
Okay. On the request of MS also. Appearing for the state respondent. The hearing is adjourned today. We have also heard Mr. Kosekopate appearing for the petitioner. When do you want it?
So 2 weeks, Your Lordship.
List after 3 weeks for hearing.
Much obliged.
Please, your lordship.
Yes,
Lordship, I like to mention item number 15. On
yes.
behalf of my senior young royalty, learned citizen.
Hmm.
Lordship, my seniors in this post, so if this matter can kindly come up on 11th March.
Okay. What is your name? The learned counsel, Mr. So-and-so. Appearing for the respondent submits that the learned CGC is not available today on personal reasons. Therefore, an adjournment has been prayed for. Have you informed the other side? The learned counsel has submitted that he has already informed the other side. Accordingly, the matter is adjourned today. List after 3 weeks. Yes. Item 1. Yes. Yes. Hmm? 15 March. 18 March. On the request of the learned counsel MS so-and-so, the matter is adjourned today. List on 18 March for admission hearing. 3. Item 3 also same order. The next day it will be the hearing. Yes. 17. Criminal appeal. 18 March. On the request of the learned counsel MS so-and-so, the hearing is adjourned today. List on 18 March for hearing. You are also, we have also heard, Mr. Paying for the respondent.
Please, my lord. Lordship, I'd like to mention item 30 on behalf of my colleague Kian Rami, Lordship. This matter can be listed after 2 weeks, my lord.
Have you informed the other side?
Lordship, I have been informed by him that they have discussed already, Lordship.
Okay. On the request of Mr. N. Angami, the learned counsel appearing for the state respondent, the matter is adjourned today. When do you want it?
After 2 weeks, my lord.
Least after 2 weeks.
Lordship, a single prayer for item 14 on behalf of additional G in team song.
14.
Yes, my lord.
Then item number 14 also same order. In item number 13, when do you want it?
After 2 weeks.
Item number 13 after 2 weeks and item.
13, my lord, I'm there, my lord.
Oh, you're there.
Yes, my lord.
Okay. After 2 weeks. You are N.K. Murray.
Yes, my lord.
We have also heard Mr. N.K. Murray, the learned counsel for the petitioners. Least after 3 weeks. And item number 14.
On behalf of team song, if matter can list after 2 weeks, my lord.
So here, the respondent number 4 is the AG, it's like on the just been informed that the respondent number 4 has been made a party. So I will structurally adhere to respondent number 4.
Okay.
2 weeks maybe done the process.
Okay.
2 weeks. Well, I've not received a copy of it yet.
Okay.
I've just been informed of it.
And Mojui, the learned counsel MS, the learned standing counsel for the respondent number 4. Has submitted that he has not yet received the copy of the petition. Also heard Mr. Learned counsel appearing for state respondents. Appellant. The appellant is directed to provide one copy of the memo of appeal to the respondent number 4.
No.
Least after 3 weeks.
No.
For admission, item number 2.
As the call, I'll file my affidavit this morning, Lordship.
For respondent number?
For respondent number 4.
4.
I'm
appearing on behalf of respondent number 5.
on the ground that I have not mentioned state of Nagaland and 6 others.
Yes.
Now, Lordship, when the petition was filed, the PIL, it was STR was state of Nagaland and others. So accordingly, I've been filing my affidavit all this time, Lordship, and others. Now, I've been specifically asked to mention 6 others. On that ground, my affidavit has been rejected, Lordship. So, for every matter, since after the post title, we filed the affidavit, Lordship.
For respondent number 4.
Yes, Lord.
Now what will happen? Your affidavit is rejected.
Rejected on the ground that I have mentioned state of Nagaland and others.
Oh, it's
6 others.
Instead of 6.
No, when the Lordship, can you see the PIL? It's state of Nagaland and others only. And all this while I have been filing my affidavit according to the first time.
Make the corrections and file the affidavit again.
You just have to change the cost title, isn't it?
Change the cost title and file it again.
Lordship, I am appearing on behalf of respondent number 5, Lordship.
You're for
As
5.
per the last respondent number 5, insurance company, Lordship.
Yes.
As per the last order, Lordship, I was directed to file an additional affidavit, thereby indicating the details of claim cleared by them during the entire year of 2025. So, Lordship, I have the affidavit ready, but the main issue is, Lordship, total there are 44,990 entries. And for printout, that is one set. The annexure only goes up to 3,280 pages.
Very big.
So, Lordship, if I need to file the hard copies of the entire claim, Lordship, that will span up to 26,240 pages. So, my humble prayer before Lordship, if I may be permitted to file the soft copy of the annexure, because that contains 44,900 entries, 990 entries, Lordship.
There are only 499 pages, Lordship.
You have only for 4.
Yes. The data will be clean.
44,990 entries, Lordship, and spanning across 3,280 pages. The entire claim that we have paid in last 1 year, Lordship.
Lordship, I can see the last order. The last order. We were being directed to file the number of rejected claims and the pending claims. Now, Lordship, as per the record, we have put on record, Lordship, they have never to be placed, Lordship. There are 2,136 CMHI's claims that have been rejected by the respondent number 5, and 2,407 claims that are pending.
That you have already filed.
But since it has been rejected, so I will replace it, Lordship. And
So now they respondent 5 only has to explain the reasons.
yes, why this has been rejected and why
Yes.
these claims are still pending.
But, Lordship, there is a direction to us in the last order that we have to file an additional affidavit by bringing on record the entire claims cleared by them during the entire year of 2025. Lordship, may kindly please produce the last order, Lordship. The last order, page 4.
My
11 to 11.
11 you order. Yes. Well, look, as per the 11 order, we are supposed to file the number of rejected claim and the pending claims under the CMHIS and the Ayushman Bharat. And if the respondent number 5 is not able to explain why this has been rejected, they are supposed to appear personally after 10 days. So let the matter be listed on next week, Lordship. I'll file the affidavit.
Lordship, it may be taken up on 18 February because, Lordship, I have to file this entire affidavit, Lordship. And even I have to respond to the affidavit filed by my learned friend, respondent number 4.
11 February is very clear. They have not been directed to file any affidavit.
Lordship, as per the order dated 28 January, Lordship.
Oh, we are talking about February.
11-2. Look at the order dated 11-2.
11-2.
11-2 order.
Yes. 11-2 order is very clear. I've been directed to file an affidavit and they are supposed to explain why they are rejecting the claims and why the claims are still pending.
Lordship may give me, fix the date on 18 February so that I can respond, and if necessary, I will bring the person from Mumbai, Lordship. He will answer. Because, Lordship, as per the MOA, we have been directed to pay all the claims.
The
And
reason
suppose if we have rejected, then on what grounds it has been rejected, it has to be responded, Lordship.
and the pending claims with the insurance company will have to be answered within 10 days. Heard Mr. N. Mujui, the learned counsel appearing for the respondent number 4.
Lord.
Whose affidavit was rejected?
Respondent number 4.
Respondent number 4.
Yes, Lord.
Mr.
If
Mujui
necessary correction will be done, we will find that.
Mr. Mujui has submitted that his affidavit was earlier rejected by this court.
By the registry, by the registry.
Oh, his affidavit was not accepted by the registry because of some errors in the title page. Therefore, Mr. Mujui submits that he will make the corrections
Lord.
in the title page of the affidavit
Lord.
and file the same again
Lord. Lord.
tomorrow. From you want to file him soft copy.
Soft copy, Lordship. As per order dated 28 January, Lordship, I have been directed to file the entire claim paid in 2025. So that comes to around 3,280 pages, Lordship. So I will be permitted to file the soft copy, Lordship, of the annexure.
You can let them file soft copy.
Lord. There will not be done. So we will release it next week.
Okay.
Because this is a 25,
Yes.
2024, 25 initial issue.
What is your name?
A. Kakoti.
The learned counsel, Mr. A. Kakoti, appearing for the respondent number 5.
5. Insurance company.
5 submits that his affidavit will consist of more than 2,000 copies.
3,280 pages.
3,280 pages. Therefore, he submits that he may be given opportunity to file the affidavit in soft form. After hearing both sides,
Throw a pen drive, Lordship. Pen drive or email as the court deems it convenient, Lord.
The prayer of Mr. Kakoti is allowed. The affidavit shall be filed through email. Okay. Raise this matter again on when do you want?
Lordship, 18 March. Because if required, I have to bring the person to answer all the.
Okay, we will give it just a week time. Or affidavit was really bad. That's because the typographical error. It has been rejected. On 25th, Lordship. Because the order is very clear. The last order. Because if they are not able to explain the rejected claim, they are supposed to appear in person.
So let them explain now.
Who will explain? Then let them appear on 18. Let's just matter on 18 March. On 18 March.
Obliged, Lordship. Obliged, Lordship.
For admission, item number 4.
Yes, listen of but this matter relates to election to the urban local bodies. There was an election in 2023. And private respondent, who is not an indigenous inhabitant of parent district, who is not a native of that particular district, has been allowed to contest the election. in the women reservation quota in Cherokee Down Council.
Yes.
And thereafter, the prison appellant came to know about her status. She is not eligible under the Municipal Act. Therefore, a petition was filed before the election tribunal. Under the Act, there is a provisions for constitution of election tribunal. So, the petition was filed there. During the pendency of that petition, the proceeding before the election tribunal was challenged by the present respondent before the Honorable Court. And the order was passed suspending the proceeding. Meantime, the petitioner who has filed the election petition before the election tribunal detected some discrepancies in the petition, so we wanted to withdraw that application before the election tribunal. And submission was made on 6/6/2025 that we may be allowed to withdraw the election petition before the tribunal and liberty may be given to file fresh election petition. That was the submission made. So the order was passed on 6/6/2025. Thereafter, the present appellant filed an application before the tribunal seeking liberty from the tribunal to withdraw the petition and to file afresh in accordance with provisions of law. Because they have something filed in the form of a complaint, which was not proper. It has to be filed in accordance with the provisions of law. So we wanted to file in accordance with the provisions of law. So on 16/6/2025, Lordships may come to page 34. After the application was filed, without hearing the respondent, the order was passed on 16/6/2025. Since the election tribunal is being made by the administrative officers, they do not know the procedures. Actually, the parties should be heard and then order should have been passed. But since the application was filed, they have passed an order without hearing any of the parties. That is at page 34. So we probably complain that how come without hearing any of the parties the order can be passed. So on the same day, next page, page 35. The tribunal has issued notice for hearing. And the order was passed fixing 18th of June 2025 at 11 a.m. for hearing of the application for withdrawal. So by this order, the earlier order which I have referred to your lordships at page 34 has been modified. So the first order at page 34 has become non-existent. It was subsequently superseded by this order where the notice was issued on 16/6/2025. And thereafter, the applicant has filed the application and before waiting for that, an IA was filed. Apparently on 19 or 20, I do not know. Lordship will find it page 42 by the present respondent. Operative portion lordships will find it page 43. (26/2025). Near it lordships. But as the Momi Learned Counsel for the applicant and Mr. I. Amgen, Learned Counsel for opposite party respondent number 2. while the order dated 6/6/2025, it was observed that since the opposite party respondent is contemplating to withdraw the election petition, which is filed before the election tribunal, municipal and town council Nagaland, a week's time was granted to place the withdrawal order before this court, and the case was directed to be listed today, that is 6/26/2025. Today, when the matter is listed, no withdrawal order has been placed before this court, and therefore, the present application seeking to recall the order dated 6/6/2025 passed by this court in the main writ petition and to hear the case on merit. Mr. I. Amjad Learned Counsel submits that he may be allowed to file affidavit to the application. This court, however, feels that no prejudice will be caused to the opposite party by disallowing the opposite party to file the affidavit and to hear the case on merit. In that view of the matter, the order dated 6/6/2025 passed by this court in the main writ petition is recalled, and the writ petition shall be heard on merit. So we are agreed by this, and then this is the Indian order. Now, can we come to page 45? This page 45 order is dated 18/6/2025. And the order, Indian order is 26/2025. Just there is a difference of 2 days. Can we come to page 45, election E? This is in the election case number 2 of 2024. Order was passed on 18/6/2025. Let me read from the second paragraph. Learned Counsel for the respondent submits that the respondent intends to file an application before the Honorable Gauhati High Court Kohima bench for recall of the order dated 6/6/2025 and to pursue a writ petition pending before the Honorable Court. Counsel for the respondent further prays for time to file written objection. This is very important. They have sought for filing written objection on the maintainability of the present application filed by the applicants, petitioners for withdrawal with liberty to file afresh. It is also submitted that a copy of the affidavit in opposition filed by the respondent shall be furnished to the applicant, petitioners forthwith. The prayer of the respondent is allowed. Let the respondent file objection on or before the next date of hearing. This is the matter for hearing on 2/7/2025. The order dated 16/6/2025 is retracted herewith. So this is an order on the order of withdrawal application. When the matter was listed on 26/2025, in view of this development, we could not produce the order of withdrawal because no order was passed during that time. And this Honorable Court passed the Indian order on 26/2025. That is just 2 days after this order. They wanted to file objection, but after making such a submission before the tribunal, they came before this Honorable Court and obtained the order on 20th. And this is. Kindly come to page 48. Paragraph 5. That the applicant speaks to state that the applicant has obtained the liberty to withdraw this instant election petition from the Honorable Court, Honorable Gauhati High Court Kohima bench, and the Procedural Court has permitted the same. Thus, the applicant may be given liberty to withdraw the said election petition with liberty to file afresh. So, as I have submitted Lordship on 6/6/2025, a prayer was made before this Honorable Court that we wish to withdraw the election petition. And we have pointed out to the Honorable Court that after withdrawal, we may be allowed to file it. So that was the prayer only. But then, while filing the IA, it appears that the applicant, the present respondent, may have pointed out before the Honorable Court that we have already obtained an order. We have already failed to obtain an order from the tribunal to place before the Honorable High Court. Now, whether to allow the withdrawal application or not, in my respectful submission, Lordships, that discretion is left with the tribunal, not this Honorable Court. It is the tribunal's discretion whether it should be allowed or not to be allowed.
Okay, today we will admit the appeal.
Last occasion, I think it was, delay was condoned.
Delay already condoned.
Delay was condoned and admitted also.
You want to say something?
Your Lordship, this writ petition, this appeal is based on falsehood, absolute falsehood. On 6th of May 2025, the only prayer which was made in the writ petition was that the appellant, the respondent, wishes to withdraw the election petition. Thus, if I may use the word thus, to emphasize the submission that I make, there was no prayer for withdrawal with liberty to file afresh. We were under the impression, this Honorable Court was also under the impression that the election petitioner wished to withdraw the election petition, simpliciter. What has he done? Your Lordship, can kindly see the order of 6/6/25, page 33. At page 33.
Yes.
It says, the learned counsel for respondent number 2 submits that the said respondent is contemplating to withdraw the election petition which is filed before the election tribunal, municipal and town council, and therefore seeks for a week's time to place withdrawal order before his court. On 6/6/2025, they took a week's time to place the withdrawal order. It was a withdrawal simpliciter, my lords. No liberty to file afresh. But what did they do? They filed an application to election at page 46. At page 46. And kindly look at the prayers here, page 48. Kindly look at the prayers, my lords. Withdraw the election petition with liberty to file afresh to condone the delay. Now, my lords, the Municipal Act prescribes the manner in which an election petition is to be filed. It must be filed within 15 days from the date of declaration. It was filed after 15 days. After 15 days. So I filed, and the election tribunal, without any application of mine, straightaway issued process. So therefore, I approached this Honorable Court, questioning the materiality of the election petition. The election tribunal ought not to have entertained the petition in the first place. And like my another friend very fairly concedes, it was not even an election petition, it was just an application. An election petition, your Lordships are well aware, must be presented in a particular format. There is a prescribed manner of presenting the election petition. First point. Second point, once an election petition is filed, can it be withdrawn with liberty to file afresh? Impossible, your Lordship. That is not a procedure, that is not a remedy prescribed in electoral law. Election petitions are serious business, your Lordship.
Yes.
You cannot be permitted to correct your mistakes. You cannot be permitted to erase your mistakes, erase your faults. Election petition, so-called election petition was filed in the form of a letter, no material facts and particulars, not supported by verification and affidavit as mandated by law, just a simple application, filed beyond the period of limitation. Therefore, we filed the application. It was stayed. They came before the Honorable Court saying that they will withdraw the election petition, simpliciter. They went before after making this clear, they went before the election tribunal, and instead of withdrawing, they filed an application for withdrawal with liberty to file afresh. That is an abuse of the process of court, and this is precisely what has happened. And now the reporter is trying to force the blame on me. So what the other single judge has said is that the liberty was given to you to withdraw the petition, not to go and withdraw and file the liberty with an application to file afresh, and also to pray for continuation of delay. And your Lordships are aware, in the Municipal Act, and there is a case in Assam from Assam, the Assam Municipal Council. The Assam Municipal Council prescribes a period of limitation of filing election petition. There is no provision for continuation of delay. There is no application of the Limitation Act. There is already a decided case. In the Nagaland Municipal Corporation Act also, there is a prescription of 15 days. That's it. There is no provision for continuation of delay. This is a short matter, my lord. So therefore, the learned single judge came to the conclusion, though not in so many words, that the appellant has misled the court. Therefore, the liberty given to withdraw the application That was recalled.
Hmm.
And the matter was decided to be heard afresh. Where is the illegality in that matter?
Hmm.
And now
Okay.
again, they're trying to delay the matter by approaching this court by filing a writ appeal. You don't want a writ petition to be heard.
Hmm.
The writ petition is to be heard on merits, Your Lordships. What prejudice does it cause to him?
Delay already happened.
Delay already happened.
Already happened delay.
It already happened.
Whatever may be the case, that may be decided by the tribunal lordship.
No, Your Lordships. The liberty was given to him to withdraw the petition, not to go and file an application for withdrawal, the liberty to file a fresh.
Okay, today we will admit the appeal.
Very well.
We'll go for hearing. Adjourned Senior Counsel, Mr. C.T. Jamil, assisted by Mr. appearing for the appellant. Heard Mr. A. G. Mani, Learned Counsel appearing for, you are for 2, 3, and 4.
Election, the return candidate. The return candidate is respondent two.
A. G. Mani appearing for the respondent number 2. Who is for the state of Nagaland?
NPM so was appearing on the earlier occasion.
Today. Today you are for state of Nagaland. Hard MS so and so appearing for the state of Nagaland. The respondent number 1. And 3 and 4.
Election tribunal may not be necessary. Actually, election tribunal will not be necessary.
What do you say?
Well, check this, on the last occasion of this has been
Okay,
deemed to be completed.
okay. Then please this matter on, you suggest on date in the month of March,
11th.
11 March for hearing.
For admission, item number 5.
We have this lordships.
Yes.
In this. As per the last quarter, 10th of September 2025.
Hmm.
That is the number of admissions.
It will, if the appeal is already admitted for hearing, it will go for hearing.
We were had to the lordship.
It will go for, today it is for admission only, not for hearing. That is why. Other learned senior counsel, Mr. C.T. Jamil, assisted by Mr. appearing for the appellant. Hard missing. Yeah, you are respondent number 1.
Respondent number 4, go back there. Yeah.
Hard Mr. So and so appearing for the respondent number 4. Then who is for other state of Nagaland? Hard MS. So and so appearing for respondent number 1, 1, 2.
3 also.
1, 2, and 3. And who is for 5?
1, 4, 5 to 9.
Hard Mr. So and so appearing for the respondents 5 to 9. List this appeal for hearing
Next week, it can be heard.
in the month of March.
Yes, I can see.
Only 1 week. we have-
After 2 weeks.
After 2 weeks means you suggest on one date in the month of March.
Huh? 4th March.
4th March.
4th March is a holiday.
Huh?
It's a
4th
holiday.
March is a holiday.
And 11.
We have fixed many cases.
Many cases on 11.
It didn't.
18
March.
18 March.
18 March.
18 March for hearing. Okay, 18 March.
For hearing, item numbers 25 and 26.
Yes.
Can we hear the other matter?
Okay, you want to feel? We'll hear it in the month of March. We'll list this appeal
25th of March,
on 25th March, along with item number 26.
same with 27, 28.
27, 28 also same. Same order.
Analogous matters. Matters are analogous.
25th,
25, 26 different, 27, 28 is different.
Oh, okay.
on 25th March,
Oh, no.
25th March. Okay.
March.